Hello and welcome to ProfDale's Property Video number 42. I'm your host, Dale Whitman. In this video, the first of two, we're going to talk about the real estate recording system. Now, recording is customary for nearly all documents that create or transfer interests in real estate. Virtually all of them do, in fact, get recorded. Virtually everybody who buys real estate first gets a search done in the public records to determine whether the seller has good title. So both the process of recording and the process of searching in those records are highly customary in the real estate field. Every state has a recording act that governs these operations, and we're going to learn how those recording acts work. Before we explore the system in detail, a few true or false questions to illustrate how the system is designed and what it's set up to do. First, true or false, the recorder's personnel will tell you who owns each parcel of land. The answer, of course, is false. That isn't their job. True or false, they know who owns each parcel of land. Once again, false, except by coincidence, they don't generally know and don't keep track of who owns each parcel of real estate within the jurisdiction. True or false, a careful search of the records will show you who owns each parcel of land. Well, the answer might be true, but there are many ways in which a search can be misleading or incomplete, so you might not actually learn the details you need to know about the ownership of each parcel of land by doing a search in those records. True or false, unrecorded deeds are void. Once again, that one's false. There's no requirement that deeds be recorded in order to be valid between the parties to them. So far as the grantor and the grantee are concerned, a deed is perfectly good even though it might not be recorded at all. The recorder's office, as we've said, isn't a place where you can go and ask who owns each parcel of land. It's much more like a library. It has lots of documents in it, and you're welcome to search in those documents, but you have to draw your own conclusions about their legal effect. Let's examine the legal principles that govern the recording of real estate documents. In this example, we have O, who is the current owner of a parcel of land. O obtained the title by a deed from some previous owner some time ago. Now on day one, O makes a deed of this land to A. And then on day two, O, who is obviously acting improperly, makes a conflicting deed of exactly the same land to B. So the question before us is which one of these two people, A or B, really owns the parcel of land? And the answer, of course, is A does, basically because A got it first. The reason is that first in time is first in right. O doesn't have any title to pass to B on day two because O conveyed all of his title to A on day one. Now that's the normal answer in the absence of the recording acts. And the amazing thing about the recording acts is they can reverse that result and allow B to prevail over A. How can that happen? In order for the recording acts to have the effect of giving B, the later purchaser, priority over A, the prior purchaser, in order for B, in other words, to prevail over A, a couple of things have to happen. The first thing that has to happen is that A, the prior purchaser, must fail to record. If the prior purchaser records his or her deed, that's the end of the story. The prior purchaser always wins. So all recording act questions, in a sense, start out the same way. A takes the property by virtue of a deed and fails to record it. Otherwise, there would be no question if A immediately recorded. Now, in order for B to prevail, it isn't enough for A to fail to record. In addition, B has to qualify under the particular type of recording act. And because there are three different types of recording acts, there are three different ways that B has to qualify depending on the jurisdiction. Let's take a look at this little chart in which we can outline the three different requirements of different states as to how B has to qualify under the recording act to prevail over A. The first kind of statute, which is often called a notice type statute, says that for B to win over A, if A fails to record, B must pay value and take without notice. Now, these are often called notice statutes, but that's really kind of an incomplete description of the statute. We probably really should call it a notice and value statute, because in order to prevail, B must both pay value for the property and take without notice of A's prior deed. That's the first kind of statute, and about half the states have that type. The second type of statute says for B to win over A if A fails to record is that B must record first. This is often referred to as a race type statute because it conjures up in our minds a picture of A and B racing each other to the courthouse, and the first one to record his or her deed will prevail. In reality, it isn't usually much of a race because the two parties don't know about each other. Nevertheless, it is true that under this type of statute, whoever records first will win. There are only 3 states that have this type of statute. They're Delaware, North Carolina, and Louisiana. The third type of statute is really a combination of the first 2 kinds. It says for B to win, B must not only pay value and take without notice, but must also record first. This is sometimes called a race notice or notice race statute, and about half the states have this type of statute as well. Now, when we read these statutes, and we are going to take a look at some in just a moment, we'll see that some terms, even though they sound different, really have the same meaning. Sometimes the statute will refer to a person as taking the property in good faith. Other times they'll refer to a person as taking it without notice. Well, those mean the same thing. If a purchaser has notice of a prior conveyance, the purchaser wouldn't be taking the property in good faith. So you can express it either way, either as good faith or without notice. A purchaser who both pays value and takes without notice, or in other words, takes in good faith, is called a BFP, and that stands for a bona fide purchaser. And that, of course, under the Recording Acts, is a very desirable status to have. Now, here's the typical wording for a notice type statute, somewhat simplified, I'll admit. It says, no conveyance is valid as against a subsequent good faith purchaser for value unless it's recorded. We can also invert the wording and change it a little bit, and it would look like this. All unrecorded conveyances are void as against a subsequent good faith purchaser for value. Now, if you look closely at the wording of this one and the previous slide, you'll see that they say essentially the same thing, only with an inversion of the wording. If we wanted to turn this from a notice type statute into a notice race or race notice type statute, how would we do it? Well, the answer is we would simply add the words who records first at the end. So it would read all unrecorded conveyances are void as against a subsequent good faith purchaser for value who records first. Finally, suppose we wanted to change it to a pure race type statute. What would that look like? Well, we'd need to strike out the phrases good faith and for value so that the statute would simply read all unrecorded conveyances are void as against a subsequent purchaser who records first. And there we have our pure race type statute. Here's an example, perhaps a typical multi-state bar Recording Act question, but I've done it in the form of a diagram, and I strongly encourage you to do the same thing. If you get a Recording Act question on an exam or in real life, it's extremely helpful to make a diagram of it that looks something like this one. So here's the way this question reads. O owns land. On day 1, he deeds it to A, but A does not record the deed. On day 2, O makes a conflicting deed to B. B's deed is also recorded, but B is a bona fide purchaser. That is, B pays value for the land, and B has no notice of A's previous deed. On day 3, A records A's deed, and on day 4, B records B's deed. Now, I'm going to walk through the answer to this with you on the next slide, but it might be helpful if you sketch this one out on a piece of paper so you can keep looking at it while we talk about the answer. So here's our analysis of that question. In a pure notice state, B is going to prevail. The reason is that B was a bona fide purchaser at the time B obtained or was delivered that deed that B received, and that's really all we need to know. In a pure notice type state, we simply don't care who recorded when or whether A recorded before or after B does, as long as we can say that A didn't record by the time B took B's deed and B was a bona fide purchaser, B will prevail. So the information about who recorded first later is totally irrelevant. Now, on the other hand, in a notice race type state, A is going to win. The reason is that B doesn't qualify under the Recording Act. Even though B is a bona fide purchaser, B didn't record first. And to qualify in a notice race type state, B has to both be a bona fide purchaser and record first. B didn't do that, so B doesn't qualify under the Act, and therefore A will win. Why does A win, by the way? Simply because of the common law. Because the common law says first in time is first in right, and in this case, the Recording Act didn't change the common law result because B didn't qualify. In a pure race state, the result is the same as in a notice race state. Once again, B didn't record first. And if you don't record first in a race type state, then the previous taker, A, will always prevail. So to review the fundamental concept of recording acts that we're talking about here, normally the priority of real estate documents is determined by the chronological order of their delivery. Whichever one is delivered first gets top priority, whichever one is delivered next gets next priority, and so on. However, the recording acts can reverse that result. They only do that if the earlier document was not recorded and if the later document's taker qualified under the state's Recording Act. And how you qualify depends on the particular state statute. You might need to be a bona fide purchaser, you might need to record first, or you might need to be both. Now, do the Recording Acts apply to things other than deeds? For example, do they apply to mortgages, to leases for longer than a year, for easements, for restrictive covenants? Well, the answer is yes to all of those. The Recording Acts, in fact, apply to any interest in real estate that is conveyed by a written conveyance. Not just deeds, but all other kinds of conveyances of all other interests in land as well. So what that means is that if you took a mortgage or a lease or an easement or a covenant and you failed to record it, it might be held void against somebody who was a later bona fide purchaser. What I'd like to show you now is that the Recording Acts really determine the priority of competing or conflicting interests from multiple conveyances of the same land. What the Recording Acts literally say is that the earlier conveyance is void against the later conveyance if the earlier conveyance is unrecorded and the taker of the later conveyance qualifies by being a bona fide purchaser, recording first, or both. We already knew all of that. But when we say that the earlier conveyance is void, we don't necessarily mean absolutely void. The earlier conveyance is void only to the extent necessary to give full effect to the later conveyance. Now, if the later conveyance is a deed, then the prior conveyance will be absolutely void. But if the later conveyance is something other than a deed, it won't necessarily make the later conveyance absolutely void, but only void to the extent necessary to give full effect to the later conveyance. So what the Recording Acts really do is determine the priority between the earlier and the later conveyances. We're going to look at some examples of that principle. The first example is the one we've already talked about, where there are two competing deeds, one to grantee number 1 and a later one to grantee number 2. And of course, normally the priority among competing deeds is determined by the chronological order in which they're placed on the property. So normally grantee number 1 will have title and grantee number 2 will have nothing. That's the common law result. First in time is first in right. However, that result, as we've already seen, can be reversed if grantee number 1 fails to record and if grantee number 2 is a bona fide purchaser and records first. In that event, grantee number 2 will have title to the land and grantee number 1 will have nothing, so grantee number 1's deed there is completely void because it's in total conflict with grantee number 2's deed. In the next example, grantee number 1 takes a deed of fee simple title to the land, and grantee number 2 only takes an easement. That second arrow is an easement deed, granting an easement to grantee number 2. Now normally grantee number 1 will have title and grantee number 2 will not have a valid easement, will really have no interest in the land at all. But once again, the recording acts can change the common law result. If grantee number 1 fails to record and grantee number 2 is a bona fide purchaser and records first, then grantee number 2 will prevail. But prevailing in this case simply means that while grantee number 1 still has valid title to the land, that title is now subject to grantee number 2's valid easement. So grantee number 2 gets priority in the sense that the easement is effective against the title that's held by grantee number 1. So grantee number 1 has to recognize the easement and allow grantee number 2 to use that easement. In example number 3, grantee number 1 takes a deed and grantee number 2 is really a bank that's taking a mortgage on the property. Now once again, under the normal common law rules, grantee number 1 has title to the land and the bank will have no interest in the land at all. The mortgage will be invalid. Why? Because the owner didn't have title to the land when they gave the mortgage to the bank, so they had no authority to give the bank any interest in the land at all. Once again, however, the recording acts can change that result. If grantee number 1 fails to record and the bank records first and is a bona fide purchaser, recording their mortgage now, the result is grantee number 1 will still have title to the land all right, but now that title will be subject to the bank's valid mortgage. That's obviously very detrimental to grantee number 1's interest. They don't want to have a mortgage executed by somebody else to affect the title to their land, because as a practical matter, they may have to pay off that mortgage in order to preserve their land from being foreclosed by the bank. But the point we want to remember is that the bank has a valid mortgage on the land that is owned by grantee number 1, because the bank has priority in this case by virtue of the recording acts. Finally, in example number 4, we have two competing mortgages, one to bank number 1 and the later one to bank number 2. And once again, normally the priority among multiple mortgages is determined by the chronological order in which they're placed on the property. So the first person to take a mortgage gets a first mortgage. The next person to take a mortgage on the same land gets a second mortgage, and so on. So normally bank number 1 will have the first mortgage, bank number 2 will have a second mortgage on the property. The owner, of course, still has title to the land, subject to these two mortgages. Now, if bank number 1 fails to record, and bank 2 records first and is a bona fide purchaser, then bank 2 will end up with a first mortgage on the property, and bank 1 will have a second mortgage instead of the first mortgage that they thought they had. This is, in effect, the penalty that they're paying for failing to record their mortgage. So literally, in this case, the recording acts determine the priority between the two mortgages, which is the first mortgage and which is the second mortgage. Naturally, it's very much advantageous to have the first mortgage on the property rather than the second mortgage, because if the mortgages are foreclosed, the person with the first mortgage gets paid off first, and there might not be enough value in the land to fully pay off the holder of the second mortgage. In fact, they might not even get paid off at all if the land isn't valuable enough to cover both mortgages. The first mortgage holder gets first dibs on the property in a foreclosure sale, and that's very advantageous. Now we're going to turn our attention to a different topic. Suppose you do a careful title search. What could possibly go wrong? And the answer is a whole lot of things could go wrong. Now in this screen, we're going to summarize the things that can go wrong in a title search. And then in the subsequent screens, we're going to look at each of those problems in detail. The first thing that can go wrong is that there are adverse interests that may exist against a parcel of land that are hard to find because you can't locate them in the recorder's office. There are two different groups of these kinds of interests. The first one are ones that are recorded in some other governmental office, but not in the recorder's office. So we have to go to other offices to look for them. We'll see those in the next slide. Then there are a group of adverse interests that are totally outside the recording system, and they don't have to be recorded anywhere, and essentially they're impossible for us to find when we're searching a title. In addition, the existing documents that are in the public records may have defects in them, but those defects may be undetectable. We look at the document and it looks just fine. We don't realize that it's defective and doesn't really convey the interest in land that it seems to convey. Then there are errors in indexing by the recorder. After all, when we look up documents doing a title search, we have to do it in the indexes provided by the recorder's office. And if they've made a mistake in indexing a document, either totally failed to index it or indexed it with incorrect information, then we won't be able to find that document, and therefore we won't be able to take its legal significance into consideration. There is also the problem of the searcher simply failing to notice a document. After all, title searchers are only human, and like every human, they can make mistakes. They can look at something that's obviously relevant and somehow, due to a mental lapse, conclude that it's not relevant and fail to pay any attention to it. Finally, there are problems of interpretation of documents. What is the legal meaning of a particular document with particular wording in it? Well, often there are varying potential interpretations, and what a title searcher believes a court will say might not necessarily be the same as what an actual court in later litigation actually says. Let's take a look at interests that are filed in other governmental offices but outside the recorder's office. One of the most common is judgment liens. Now, in some states, judgment liens are filed in the recorder's office, but in other states, they're filed in the clerk of court's office, usually a different office in the same building in the courthouse. So we've got to go over to the clerk's office and look through the docket records of the court in order to see if there are any judgment liens against an individual that we might be buying property from. Then there are lis pendens documents, the concept of pending litigation. Once again, in some states, those are recorded in the recorder's office, but in other states, they can be found only in the docket records of actual litigated cases in the clerk of court's office. There might be eminent domain actions filed by a government agency against the property, and those would be available to us typically only through the records of the clerk of court's office. If there are federal bankruptcy filings, then we'd need to go to federal court to discover those. So the federal filings are just as relevant as state court filings, and we need to take a look at both. Property tax and assessment liens are usually found in some taxing office of the county, such as a tax assessor, tax collector, it might be called the auditor. The name varies from state to state, but somebody is in charge of those records, and it normally is not the recorder's office. There might be other state tax liens found in other government offices. For example, in some states, if there's a water company that's owned by a city or county government and they don't get paid on a bill that they've sent to a customer, they can file a lien on that customer's real estate, on their house or business. But again, those aren't going to be found typically in the recorder's office. They'd be found only in the water company's office. So there's another place we need to look. Finally, there are municipal ordinances like zoning and subdivision control and housing codes and building codes. All of those are going to be found not in the recorder's office, but usually in the office of the planning department of the city or county. Now, technically, those municipal ordinances don't affect the title to land, but they're highly relevant to anybody who buys a parcel of land. You certainly will want to know about them, and you're going to have to look outside the recorder's office in order to find out about them. Second type of interest that's hard to find are interests that are outside the recording system because there's no document. In other words, they're created by conduct of the parties rather than by a written piece of paper. And that means they don't have to be recorded because there's literally nothing to record. And in turn, that means that they're valid even against a later bona fide purchaser, even if they're not recorded. Short-term leases are the most obvious example of this. In most states, leases that are shorter than 1 year are outside the coverage of the recording acts, and they're valid whether they're recorded or not. It's okay to record them, but they don't have to be in order to be protected against a later bona fide purchaser. Then there is title by adverse possession. We all know from previously studying adverse possession that it arises not from a document, but from the conduct of the adverse possessor. And it happens automatically. When the adverse possessor has completed the process, has been on the property for the required number of years, they automatically and instantaneously become the owner of the property. But there's no document that they can record, and therefore they don't have to record in the public records in order to be protected against the later bona fide purchaser. The same is true of prescriptive easements, of boundary changes by acquiescence or by oral agreement. Then there are potential community property claims of undisclosed spouses or other spousal property claims. If we don't know that somebody is married, we can't tell that there's a problem when their spouse hasn't signed off on a deed by which they have conveyed their interest in a parcel of land. So we may not be aware of the existence of the spouse, and they may come back and demand their interest in the land at a later time. Finally, there's a group of liens called mechanics liens. They're fileable by somebody who does work on a piece of property, does repair work, for example, or puts on a new roof or a new furnace, and doesn't get paid. The problem is that in many states, probably most states, the mechanic has up to, let's say, 6 months after they complete the work in order to file their lien. And until that 6 months has passed, we can't tell by looking in the public records whether they're going to file a lien or not. If the property is sold to somebody who thinks they're a BFP during this period, that BFP will still be subject to the unfiled mechanics lien once it does get filed, because when it's filed, it relates back to the date, typically the date the work was completed on the property. Now, this is a shameful thing to put in any legal system, to allow this sort of secret lien to exist. Nevertheless, it's well established and we have to be aware of it. Now, here's an actual case that shows you how someone who acquires property by adverse possession doesn't need to record in order to be protected against later bona fide purchasers. In this example, Mrs. Muggas lived in her house on the south side of the two lots that you see there, and she went back in her backyard and then went over her boundary about 10 feet, put up a flimsy wooden fence, and then planted a garden in that 10-foot strip. She maintained the garden and the fence for more than 10 years. That happened to be the adverse possession period in this jurisdiction. So she had actually acquired title to that 10-foot strip by adverse possession. Then she quit maintaining the garden. The fence itself kind of fell apart and rotted away and was no longer visible. There was nothing left on the ground to show that there'd ever been a garden there. But that didn't mean that she lost her title to the strip. She still had it, even though it wasn't apparent on the ground. Then the Smiths bought the property on the north side, and you can imagine Mr. Smith going back in his backyard, maybe to put up a swing set for his children to play on, and starting construction of the swing set. Mrs. Muggas might have come out of her house and said, "Get off my property." And Mr. Smith said, "Ma'am, I'm sorry, but this is our property. Our boundary line is over there another 10 feet. And she might say, "I've already acquired this strip by adverse possession, and you can't use it because it belongs to me." So if the parties litigated this, which they actually did, the court would decide that she actually owned the 10-foot strip. And the Smiths might say, "Well, wait a minute. We tried to do a title search. We didn't see any evidence in the public records that she owned this strip at all." And the court might say, "Yeah, you're exactly right about that. There is nothing in the public records that shows she owns it. Nevertheless, she does own it, and her ownership prevails over you as a later bona fide purchaser." Now, in a way, the case is kind of frightening. It illustrates how one can do a title search in the public records and end up with an incorrect conclusion because adverse possession is simply outside the coverage of the recording acts. We mentioned before that recorded documents might be defective and therefore ineffective even if a bona fide purchaser claims title through them and even though they're recorded. In other words, you can't necessarily believe everything you see in the public records. A deed in the public records might be a forgery. It might be undelivered, and a deed doesn't take effect until it's delivered. It might have been executed as a result of fraud and therefore might be void for that reason. You can't detect typically any of those problems by looking at the document in the public records, so you're likely to conclude that the document is okay when in fact it doesn't convey anything. The point to remember is that recording a document doesn't make it any better than it was before. If it was defective before and you record it, it's still defective. One final problem is the fact that a document that exists in the public records might not be correctly indexed or might not be indexed at all by the recorder's personnel. And if it's not properly indexed, we won't be able to find it because we can only find documents by looking in the indexes. So if the document is there but is not correctly indexed, in some states it is still treated as being recorded, even though as a practical matter it's impossible to find. Now, I think very little of a court that would hold this. I would say that if it's not properly indexed, it should be treated as if it isn't recorded at all. But nevertheless, a number of states have decided that if it's in the records, even though you can't find it in the indexes, it's still recorded and therefore still satisfies the Recording Act's requirement that the prior deed or other document be recorded. Now, overall, you can see that our recording system is far from perfect. As a matter of fact, it's more like a piece of Swiss cheese. It's full of holes. It can easily yield incorrect results, even to someone who does a very careful title search in those records. You can easily see why people buy title insurance, because title insurance will actually cover the person who's insured from most of the problems that we have outlined in this little review of the recording system. Well, that concludes video 42, which covers the basic structure of the recording system and some of its defects. In our next video, video number 43, we'll cover how one becomes a bona fide purchaser under the recording system and also talk about how titles are searched. If you have questions or comments, email ProfDale01@gmail.com. Thanks for watching.